Welcome to Myth Busting, the myths that disability insurance policyholders believe about ERISA and individual disability insurance and the truth. Today's myth is my disability policy will provide me with financial security if I'm disabled and unable to work. I set the stage for this segment by explaining how offsets can destroy the value of a disability policy, but I want to talk more about what is and what's not offsettable. As I said in our next podcast, I'm going to take on the thorny issue of Social Security disability offsets. So let's start with what's non-deductible. And again, you should get out your disability policy. Most disability policies are going to have a specific policy provision that explains in detail what is a non-deductible source of income. It's important that you review the laundry list that's in the disability insurance policy of non-deductible sources of income so that you know what amounts can't be deducted as an offset from your benefits. So a typical provision might say, pay now will not subtract from your gross disability payment income received from, but not limited to, the following sources: 401k plans, profit sharing plans, tax shelter annuities, stock ownership plans, non-qualified plans or deferred compensation, pension plans for partners, military pensions and disability income plans, private disability insurance, franchise disability income plans, retirement plans from other employers, individual retirement accounts, individual disability income plans, salary continuation, or accumulated sick leave plans. Now, that's quite a laundry list, but I want you to remember that these policy terms can change on a yearly basis. So what may have been a non-deductible source of income when you got the policy may now be deductible. So again, you want to make sure that you've got the current policy or plan that you are covered under. So in doing your pre-disability planning, you want to make sure, one, that you've got the policy for the correct policy period. So if you're thinking about applying for disability now, you want to get your disability policy or plan for 2020. You need to review those sources of non-deductible income because you may be relying on them to supplement your income. Because you're most likely going to be leaving your employment and your employer may pay you a certain number of weeks of salary as salary continuation, where you may have to take monies from your 401k plan. You need to be figuring this out before you stop work and apply for your disability benefits. So I'm going to talk in greater detail about the deductions from your long-term disability benefits when we come back. Welcome back. After you've located the policy provisions that help you arrive at your gross disability benefits, the next and most important calculation is to find those policy provisions that reduce your monthly benefits. Your gross monthly benefits are going to be reduced by those takebacks or offsets. And remember, I'm going to talk about the wonderful world of Social Security offsets next week. It's crucial that you know the source of income that's going to be subtracted from your disability benefits so that you can determine whether or not you can live on the amount of money you're going to receive from the disability insurance company and how you might be able to supplement that income by the non-deductible sources of income. As always, we've got to start with that blasted policy or plan. The typical policy wording I see is, what are deductible sources of income? Workers' compensation. Pay now will subtract from your gross disability payment the following deductible sources of income: the amount that you receive or are entitled to receive under a workers' compensation benefit in a monthly payment, or any amount you receive for workers' compensation benefits. Now, most short-term disability group plans don't allow for you to receive both workers' compensation and disability benefits. But again, you need to check that out and look at your specific short-term disability plan or a policy. For long-term disability insurance purposes, the amount that you receive in workers' compensation benefits is considered an offset or reduction. And this can include any amounts you receive for occupational disability like black lung disease. And remember, if you are in a state like New York, New Jersey, or California that provides you disability disease-related monthly income, those monies can be used to reduce your gross disability benefits. And unfortunately, disability contract language varies on how a disability insurance company can prorate and offset the workers' comp benefits. If you are receiving workers' comp disability benefits, be it temporary total, temporary partial, wage loss, permanent impairment, permanent total, there is normally a dollar for dollar reduction in the long-term disability benefits. So, for example, let's say you're receiving $2,000 per month in long-term disability benefits and $1,500 per month in workers' comp benefits, your net long-term disability payment will be $500 a month. Now, don't forget the disability insurance carriers can also deduct workers' comp settlements for the disability portion of your settlement. And again, we have to go back and look at the language because sometimes it's not really clear whether the whole workers' comp settlement is going to be offset, even if it includes medical benefits, which is why I always ask the workers' comp attorney to break it down by category so I have something to fight about. Rarely does the carrier offset monies received for medical expenses or fees, but there are some greedy pigs in the terms of disability carriers who will try to prorate your disability settlement, workers' comp settlement, without regard to the specific terms of your policy or the specific terms of your settlement documents. So I think before you settle your case, it's important that you or your work comp attorney review this provision of your disability insurance policy, because you may be getting a letter that says, hey, we're the disability carrier. We know you got a comp case. We want some money back, and don't ignore us. And even if they don't send you the letter, you can't ignore them. So as I've said, it's important, I think, for you to allocate your work comp settlement to past and future medical expenses, compensation benefits, rehabilitation, attorney's fees, and costs. So it's really clear what's being paid for what portion of your damages. Historically, the indemnity or medical part of the comp settlement is generally prorated over the maximum benefit period of time in your disability policy. So if, for example, you're receiving $2,000 per month in LTD benefits that are payable to age 65, and you settle your case for $6,000, your case is going to be prorated. And what do I mean by that? Of the $60,000, let's say $6,750 is attorney's fees and costs, and $30,000 is attributable to your medical expense. The remaining amount of the $23,250 will be prorated over the number of months it takes to you get to the maximum period of time in your policy. So that would be, to age 65. Well, what's next? What are the deductible sources of income? State compulsory benefits and auto PIP claims. Policies will say the amount that you receive or are entitled to receive is disability income payment under any state compulsory benefit act or law, automobile liability insurance policy, another group insurance plan, or governmental retirement system payments that you have because of your job with your employer. What this means is that group disability contracts have offset language for any amount that you receive that you're entitled to receive as disability income under a state compulsory benefit act or law. So as I've said, if you live in New York, New Jersey, or California, you have state mandated disability laws, and the money that you receive from the state's going to be used to reduce your monthly disability insurance benefits. You should check with your state to see if you're entitled to disability payments in case of sickness or injury so that you can understand if there's an offset. Now, that language that I just read to you includes PIP benefits. What are PIP benefits? I mentioned these a couple times, but state laws generally have automobile insurance liability laws that require that you, the driver, have insurance, not only liability insurance to cover damage to your vehicle or to the vehicle that hits you, but that you have something called personal injury protection benefits. Here in Florida, PIP benefits take two forms. There are money benefits and there are medical benefits, and they're all capped. But you need to understand that if you're receiving personal injury income protection benefits because you've had lost wages as a result of your auto accident, that is going to be offsettable by the disability insurance company. And if you receive any additional governmental or retirement system account monies paid to you by your employer, that can be deducted. So if, for example, you work for a municipality or an employer that has a covered disability policy, and they are paying a portion of monies to retirement system benefits, those benefits in terms of the employer contribution may actually be deductible by the long-term disability carrier. What are other deductible sources of income? Personal injury settlements. Now, that provision has so many different versions that you really have to get out your disability policy, because it can be just for the lost wages or loss of income potential. It can be for everything, and it can be prorated. There's no rhyme or reason. I was hired recently to address an issue involving a horrendous collision in Utah. The policy holder was in a vehicle driven by his daughter, who was just learning to drive, and she rolled the car, causing horrific injuries to not only him but the wife. And each case was settled for $500,000. And the disability carrier said, "Hey, we want every blasted dime of that $500,000 back." Ultimately, what I had to show, because there wasn't any clear language in the settlement documents, was that the medical expenses for both of them were going to exceed the $500,000. I mean, he needed multiple surgeries, had spine injuries, leg injuries, had a brain injury. And so I was able to convince, after the fact, the disability insurance carrier that they did not have a lien and reduce his future disability benefits or sue him, because he had actually taken the money and bought a house. There is case law across the United States that says if you spend the money from a settlement and it's gone, but you buy something that we can seize, we have an equitable right to get our money back, and we can sue you and seize that car or that house and sell it, and we can take that as reimbursement of some of the monies that you owe us. Yes, they can really do it, and yes, they really do it. So you can see that the truth is that offset provisions can destroy the value of an ERISA policy, and the time to find out is now, not when you stop working and apply for benefits, and not when you're sitting in a mediation or when you're about ready to sign a set of settlement documents. Got it? Next week, we're going to take on myth number 6. My disability policy will provide me with financial security if I'm disabled and unable to work, and my benefits can't be reduced by the receipt of Social Security disability that I get for myself or my children. In the next segment, I'm going to tell you the story of a Florida personal injury law firm that got sued because it ignored public's group health care lien on the proceeds of a personal injury settlement.